Please be seated and remain quiet. Make sure all cell phones are off. Good morning, Your Honor.
Good morning. Good morning. So there are several administrative matters to take up before we bring the jury up. The first of which is, in my discretion, I'd like to allow the jurors to use notebooks throughout the trial. So unless anyone wishes to be heard on that practice, I would provide the jurors with notebooks and provide them with the instruction on keeping notes and that sort of thing. The bailiffs have also suggested an easier way of, with respect to exhibits that are handed or published to the jurors rather than collecting them at whenever they're no longer needed. Each juror will be provided with an envelope that they'll be asked to just simply slip the documents into, and then that envelope will be emptied out at the end of each day. I think that's a more efficient practice. So any objection to those procedures?
No, sir.
No, sir.
All right, the next item, the question was raised as to when the sequestration order should take effect as far as any witnesses who are in the courtroom now. My general practice, go ahead, Ms. D.
And I just wanted to mention, Your Honor, I don't know if it would make a difference in that, but some of those witnesses would be purely mitigation witnesses, so they wouldn't have any involvement in the guilt-innocence phase of the trial, and I don't know whether maybe the rules could be a little more flexible if they are witnesses who are at the most going to be called at that point.
All right. My general practice is to require sequestration at the beginning of opening statements, but I'll hear from the state.
I
Do you have any
position.
preference?
I don't have any position on this, Your Honor.
There can certainly be an exception if, Ms. D, if in good faith you're saying that there are certain people in here who are solely mitigation witnesses. If they wish to stay for the opening statements, then I think that's fine. And if you wish to confer with counsel for the state and see whether any further exceptions need to be noted for the record, that's fine with me. But so the general rule is that any witness who, certainly any witness who will be called in this phase of the trial is asked to leave the courtroom at this time pursuant to the sequestration order that was previously entered.
And I think we did make or two exceptions. Is Detective Brady is obviously the lead, and then Miss Wallace is one of the witnesses that will be testifying, and also the victim's mother.
That's fine.
And we had analogous exceptions for the paralegal and the investigators, and they are here as well for the record.
And that's fine. All right. The next question was the issue of Harbison. Ms. Brown, do you have anything to be heard on that?
Yes. We will, in opening statement and throughout it, and we have talked with Mr. Smith about this, be not conceding anything about the crime itself, but we'll be conceding that earlier that evening he was involved with the other two co-defendants in breaking into cars and was with the co-defendants before and after the incident and was involved in selling stolen items afterwards, i.e. a laptop.
Of Harbison case, I think it's appropriate to go ahead and speak with Mr. Smith about that. And have you discussed with Mr. Smith the conversation that I intend to hold with him?
Well, we told him that you would probably want to talk to him about some of those things and make sure he'd been informed about him. We didn't give him any sense of what the format would look like, but we did tell him this conversation would occur.
Right. So, Mr. Smith, I want to have a conversation with you, ask you some questions about the information that I've just been provided by your attorney about the strategy that your attorneys intend to follow in this case. And first of all, I want to remind you that you do have a right to remain silent. Anything you say to me can be used against you. Do you understand that right? Yes, sir. All right. So the questions I have for you are, have you had an opportunity to discuss this case with your attorneys?
Yes, sir.
And have you specifically had the opportunity to discuss with your attorneys the strategy that they intend to follow in the trial of this case?
Yes, sir.
And it's my understanding, sir, that the attorneys believe that it is in your best interest that they acknowledge to the jury several points, and these points are matters that without your lawyers acknowledging this to the jury, the state would be required to prove this beyond a reasonable doubt. Do you understand?
Yes, sir.
All right. And so these points are that earlier in the evening of, the date is May
13.
May 13, 2012.
13.
May 14,
May 14,
2013.
2013.
Well, I think this part
Yeah.
we're talking about is May 13.
Okay, sorry.
Yes, I get.
So now I just made that whole a very confusing record.
All right. So prior to the crime that is alleged to have occurred that is on trial in this case that occurred on May 14, 2013, your attorneys intend to concede to the jury that on the day before or some period of time before that, you were involved in breaking into automobiles with the with the co-defendants, Mr. Anthony and Ms. Redden.
Yes, sir.
The next thing that will be conceded is that you were in the presence of Mr. Anthony and Ms. Redden both before and after the crime that is on trial in this courtroom that occurred on May 14, 2013. And the third point is that your attorneys intend to concede that you were involved in selling stolen property, namely a computer, sometime after the crime that's on trial in this courtroom. So do you understand those points that your attorneys intend to concede to the jury? Yes. And again, you understand that if your attorneys concede these points to the jury can accept that as truth. And it relieves the state of its obligation to prove those points beyond a reasonable doubt. Do you understand that? Yes, sir. All right. And have you agreed with your attorneys that they may pursue this strategy on your behalf? Yes, sir. All right, and you understand the strategy that they're pursuing, is that correct? Yes, sir. All right, very well. Anything further, counsel, on this issue?
No, sir.
No, sir.
All right, very well. All right, I'm going to find that the strategy outlined by defense counsel, which involves conceding these three specific points, is understood by the defendant and has been accepted by the defendant, and he has permitted and agreed that his attorneys may proceed with that strategy, fully understanding the implications of that. All right, are there any other matters that we need to take up before we call for the jurors?
Your Honor, there were a few questions. We did meet with Ms. Redden yesterday afternoon. We talked with her for about an hour. I would say there was nothing substantially different or new from the information that she provided. She did provide some details on some issues, but nothing substantially new. That defense counsel has a copy of that interview at this time. So I know that was an issue that was raised yesterday.
Yes.
And just to be clear, we haven't had any opportunity to review it. So whatever those additional details are, we don't know them now.
All right, that'll be fine. All right, in that case, let's go ahead then and call for the jury. And if, yes.
One of the things that we neglected to discuss yesterday was the defendant's school records, which you had initially agreed to give to us, and I understand they have filed an ex parte motion to keep those. And so I guess the question is we probably need to deal with that issue at some point.
I'll have an answer for you by the end of the day.
Okay. And also, if we could add Michael Langley to the state's witness list, who was the maintenance worker for the Allister.
All right, very good. If we could then now call for the jury.
It probably will testify her report card and some substance abuse records from the client's mother. Thank you.
All right, anything else?
No, sir.
All right, let's call for the jury then.
Good morning, ladies and gentlemen. Welcome back. It's been several weeks since we've seen some of you and several days since we've seen others of you, but we are now ready to begin the trial of this matter. Before we do that, I'm going to have two things happen. One is I'm going to ask the clerk to re-swear you in open court here, and then I'll have you impaneled. So, Ms. Harrell, would you administer the oath to witnesses? And if you would, there are Bibles there. If you wish to be sworn on the Bible, if you'd perhaps share it with your neighbors, so everybody who wishes to place their hand on a Bible, please do so. Yes, please.
Jurors, if you would please stand. If you would repeat the oath after me and raise your right hand, place your left hand on the Bible. Say your name aloud. I do solemnly swear that I will support and maintain the Constitution and laws of the United States and the Constitution and laws of North Carolina, not inconsistent therewith, and I will faithfully discharge the duties of my office as a juror. So help me God. The second oath, I will repeat it. You will say yes, I will, or I do. I do solemnly swear that I will truthfully, without prejudice or partiality, try the issues in civil or criminal actions that come before you and give true verdicts according to the evidence. So help you God.
Yes.
Thank you.
All right, thank you. If you'll remain standing just for a moment, we'll have the courtroom clerk now impanel you as jurors.
Ladies and gentlemen of the jury, you have all been duly sworn and are now impaneled to hear the evidence, wherein the state of North Carolina versus Travion Smith. Sit together, hear the evidence, and render your verdict accordingly.
Have a seat, please. All right, bailiff, if you'll collect the Bibles from the jurors, please. All right, ladies and gentlemen, you've been selected and impaneled to serve as jurors in the case of the state of North Carolina versus Travion Smith. And at this time, I want to explain to you the manner in which we will proceed as we attempt together to find the truth in this case. First of all, the attorneys will have an opportunity to make an opening statement. The purpose of an opening statement is narrow and limited. It is an outline of what the attorney believes the competent and admissible evidence in this case will be. An opening statement is not evidence, and you must not consider it as evidence. Following the opening statement, evidence will be offered. Witnesses will be placed under oath and will be questioned by the attorneys. It may be that documents and other tangible exhibits will be offered and received into evidence, and it may be that those exhibits are given to you to examine. If you are given an exhibit to examine, you should examine it carefully, individually, and without comment. It is the right of an attorney to object when testimony or other evidence is offered that the attorney believes is not admissible. When the court sustains an objection to a question, the jurors must disregard the question and any answer if one has been given, and you should not speculate or guess as to what the witness might have said had the witness been allowed to answer. When the court overrules an objection to any evidence, you must not give that evidence any greater weight than as if the objection had not been made. If the court grants a motion to strike all or some of the answer of a witness to a question, you must disregard and not consider the evidence that I instruct you has been stricken. Now, during the course of this trial, there may be questions of law that arise that require our consideration outside the presence of the jury. When that happens, I'll ask you to leave the courtroom for a few moments. If it's a relatively short matter, I'll send you back to the deliberation room to wait for us. If it's going to take us a bit longer, I'll call a recess for your benefit while we continue to work. But in any event, you should not worry or speculate about what occurs in the courtroom during your absence. Again, these are matters that the law requires us to consider outside of the presence of the jury. You should rest assured that all of the competent and admissible evidence in this case will be presented while you're in the courtroom.
Once the evidence is completed, the attorneys will have an opportunity to make a final statement or a closing argument, and these final arguments of the attorneys are not evidence, but are given to assist you in your evaluation of the evidence. Your duty is to decide the facts from the evidence. You and you alone are the judges of the facts. It is important that you be fair and attentive during the trial. You will see and hear evidence, and you will decide the facts. You will then apply the law that I will give to you to those facts. I've already gone over the rules that you must follow while you serve as a juror, and of course you've each signed a printed copy of those rules. I do want to go over them one more time in detail, and as you know, I do remind you of these rules frequently throughout the trial. I do that because these rules are very important, and it is essential that you follow them throughout this trial. So I do ask that you listen carefully to the rules, that you understand the rules, and follow them to the letter throughout this trial. So the first rule, again, is please don't talk about this case among yourselves. The only place that you can talk about this case is in the deliberation room, and then only at the end of the trial after I've instructed you to begin your deliberations. Secondly, you must not talk about this case with anyone else, including members of your family or co-workers or anyone else. Don't allow anyone to discuss this case in your presence. If anyone were to attempt to communicate with you about this trial, you should bring that to my attention immediately. And again, in this age of instant electronic communications and research, I want to emphasize that in addition to not speaking face-to-face with anyone about this trial, you should not engage in any form of electronic communication about this trial, including but not limited to Twitter, blogging, Facebook, texting, instant messages, or any other means of electronic communication or posting or status posts. Third, as you sit as a juror in this case, please don't form or express any opinion about the outcome of this case, namely the guilt or innocence of the defendant, until you begin your deliberations. In other words, we ask that you keep an open mind throughout these proceedings. Fourth, please don't talk or communicate in any way with any parties, witnesses, or lawyers involved in this case. This rule applies both inside and outside of this courtroom, and it applies to even casual conversations such as the time of day or the weather. In a few moments, you'll be given a red badge that you'll be asked to wear throughout this trial. You should take it home with you at night, take it off when you get in your car in the parking lot, put it back on in the morning when you leave your car as you're approaching the courthouse. That way, all of us can recognize you as jurors, and we can all avoid any inadvertent communication with you as well. So we do ask that you wear those red badges throughout this trial. Next, we ask that you not read, view, or listen to any media accounts of this matter, including television, newspaper, radio, or internet accounts. I instruct you that these accounts can be inaccurate or they can contain information that's not appropriate for jurors to consider, and so you should not read, view, or listen to any media accounts. Again, there is media coverage of this case, but your verdicts must be based solely on the evidence that's presented during this trial and no other source. Next, you must not conduct any independent investigation into these matters. That would include visiting the scene of the incidents alleged in this trial or researching any subjects, researching the people, places, law, facts, or things, or anything else related to this case. If you have internet-enabled devices like an iPhone, please don't use it during the trial or the deliberations to look up definitions or any other form of research as you participate as a juror. Now, each of you must obey these rules to the letter. Unless you do so, there's no way the parties can be assured of the absolute fairness and integrity of this process. It is your duty while this trial is in process and while it is in recess and while you're in the jury room to see that you remain a fair and impartial trier of the facts. These rules are an order of this court, so your failure to follow them could subject you to contempt of court, but more importantly, as you can tell, these rules are designed to ensure the fairness of these proceedings for all involved. A couple housekeeping matters that I'll just bring to your attention. First of all, the schedule that we follow. We generally start court at 9:30 in the morning and recess at 5 o'clock in the afternoon. I try to keep to that schedule as promptly as possible. You can help in the schedule by arriving with plenty of time for us to get started. I'll do my best to make sure we recess no later than 5 o'clock because we know that you have busy lives outside of this courtroom and we want to respect your right to use that time as you need to. We take breaks and recesses throughout the day. We take a mid-morning recess of about 15 minutes. We take a lunch recess. Usually we'll break for lunch between 12:30 and 1 o'clock. and we take generally an hour-and-a-half lunch recess, and then we'll take a mid-afternoon recess somewhere in the middle of the afternoon of 15 minutes as well. If there comes a time that you need a break at any time, just simply let us know, signal the bailiff or myself, and we'll do our best to accommodate you. If there's a time that you need a break for any reason at all, we'll be glad to do what we can to accommodate you. The jury deliberation room that the bailiff may have pointed out to you as he came in this morning is your room for the remainder of this trial. That's on a secure hallway, so you should feel free to leave personal items back there. If you want to bring a sweater, or if you want to bring snacks or lunch or reading material, you're welcome to leave that material back in that room. Again, that room will be your room throughout the duration of this trial. You'll note from time to time, you'll see me working on the computer or researching legal materials that I have available for me here at the desk. I'm generally working on matters related to this trial, and I am listening to every word that's being said in this courtroom, but I point that out to you because I don't want you to be distracted by anything that I am doing at the bench. Your job is to listen intently to the evidence that's presented in this case, and you should not draw any inference from anything that I am doing that any of the evidence is more important or less important. All of the evidence in this case is important, and it is your duty to listen to all of the evidence intently. If there comes a time that you can't see or hear something that's being presented in the courtroom, please call that to our attention immediately so we can take steps to make sure that you can see and hear everything that's going on. In my discretion, you'll be allowed to take notes during this case. When you begin your deliberations, you can use your notes to help refresh your memory as to what was said in court. I caution you, however, do not give your notes or the notes of any other jurors any undue significance. While taking notes, a juror may fail to hear important portions of testimony. Any notes taken by you are not considered evidence in this case. Your notes are not an official transcript of the trial. And for that reason, you must remember that in your jury deliberation, notes are not entitled to any greater weight than the individual recollection of the other jurors. If you do take notes, you may disclose them only to your fellow jurors during the deliberations. You should not show them to anyone else. And while I do permit you to take notes, I'll instruct you to listen intently at all times to the testimony. The bailiff will provide notebooks to you in a few moments, and he'll provide pens to you. If you wish to take notes, I ask that you use those notebooks that he will provide to you for your note-taking. If you run out of pages or the pen runs out, just simply let the bailiff know. We can certainly provide more for you. Those notepads remain in the courtrooms at all time until you begin your deliberations. In other words, when you go on breaks and recesses, I'll generally remember to remind you, or if I neglect to, if you'll remember yourselves, just leave them in your chairs. In the evening, the clerk will take them up and safeguard them overnight. They'll be returned to your chairs in the morning for you to use. The only time they'll leave the courtroom is when you retire to begin your deliberations. Also, if you are given evidence to review, a document or something for you to review, and you wish to take notes or highlight portions of that document, please do so in your notepads and not on the document itself. Generally, we'll collect that evidence back up from you, so if you were to make notes on that document, you would not have the benefit of those notes once you begin your deliberation. Now, I do want to mention again the possibility of news media coverage during this trial. You may have noticed television cameras or camera equipment in the courtroom. Media coverage of jurors is expressly prohibited at any portion of this proceeding, including the portion where the jury was selected. The operators of the camera and the photographers are not permitted to take pictures of you. Therefore, you should not even consider whether this trial or any portion of it will be covered by the media by any of the means I have mentioned. It will not affect you personally or the trial, so I urge you to put that matter out of your minds. All of that being said, we're going to now turn to the opening statements of counsel. We'll hear first from the state, and if defense wishes to make an opening statement at this time, then we'll also hear from the defense following the state's opening statement. Opening statements for the state. Bailiff, you go ahead and hand out the badges and the notebooks.
We're good. And everybody should have a notebook, and it should have a number on it that corresponds with your seat. All right, very good. Opening statements for the state.
Yes, sir. Melissa Huggins-Jones moved to the Allister at North Hills on about April 26th of 2013 with her 8-year-old daughter, Hannah. You'll hear that she recently had divorced from her husband of many years, and she was looking for a new life for her family. She had the hopes that her 11-year-old son, Noah, would join them after he finished the school year in Tennessee. She had a good opportunity with her job at First Tennessee Bank to move to Raleigh, where they had opened their first branch in the state. That move would bring her closer to her mother and father and step-parents who lived in eastern North Carolina, and she moved to the Allister, which was a community that advertised itself as a peaceful setting, urban location. You're going to hear that Hannah and Melissa had only been here for about 2 weeks before she was brutally murdered in her bedroom while her 8-year-old daughter was in the room next door at the age of 30. In the early morning hours of May 14, 2013, the state will prove to you that there were 2 intruders that came into her home, that confronted her in the area of her bedroom where she put up a struggle, and she was bludgeoned and beaten to death. You're going to hear from the medical examiner who describes that she had both blunt force and stabbing wounds to her head, her neck, her torso, her arms, and her nose was practically severed from her face. Luckily, during all of this, Hannah was asleep in her bedroom and had the unfortunate experience of having to find her mother the next morning in that bloody and deceased state and could not wake her. You've heard that the Allister apartments were under construction still. Melissa was one of the very first people who had moved in there. Hannah ran out in her nightgown with no clothes and luckily was able to find 2 construction workers who brought her back to the house and made that 911 call that started the investigation, which brings us here today, wherein the defendant, Travion Smith, is charged in connection with Miss Huggins' death, with the first-degree murder of Miss Huggins-Jones. You're going to hear shortly from those 2 construction workers that found young Hannah and brought her back. You're going to hear from the other professionals in that particular area who helped to try to shield Hannah from the reality that was in her home. You'll hear from Raleigh Fire Department, Raleigh Police Department, the Wake County emergency medical personnel that came there to the scene to find Melissa's lifeless body and bloody scene and began an investigation. When they started the investigation into Melissa's death and tried to start figuring out the other tenants in that apartment building, they learned that not only had Melissa's apartment on the 2nd floor been broken into, but directly below her house, directly below her apartment, there was a leasing office that was in an apartment, and you will hear that it was also ransacked. You're going to hear that from the leasing office there were 2 computers, a silver and an orange Lenovo that were stolen, an iPad, and a camera. From Melissa's home there were several items stolen, significantly her iPhone, which I think her family will tell you she was never without. At that point, Raleigh Police Department starts an investigation and tries to list those electronics that have identifying information in a national crime database in the hopes that maybe one of those would be a key piece of evidence, because for approximately 1 week, they had no real leads in this case. You're going to hear that Detective Brady was assigned to be the lead agent in this case, and he involved multiple other investigators to try to solve Melissa's death. You'll hear that they had checkpoints asking people who were in the area. They canvassed anywhere they could think of around the area. And in doing so, and in shortly thereafter with finding Ms. Huggins-Jones, you're going to hear that there were some reported car break-ins in the area, and you'll see photographs of this Allister in the area near Ramblewood. And some of those folks who lived in the area had seen things and had reported things. But on May 20th, the police department finally got a break. Here it is about a week after Ms. Huggins-Jones has been found. You're going to hear that Detective Zeke Morse with the Raleigh Police Department had been looking for those items. Again, they had put those computers in the National Crime Database. He found a computer listed on Craigslist that appeared to be that orange Lenovo stolen from the downstairs office on the night or early morning hours that Melissa was killed. You're going to hear that he had already contacted Lenovo. They had talked to anyone they could think of to see if, is there any tracking capability on this computer? Is there anything identifying about this computer that we can look for remotely? But luckily, the folks who posted it on Craigslist listed each of its specific characteristics, the capabilities, the Microsoft Office that was installed, and that's where police got their break. They were able to identify that the Microsoft installation had a unique serial number that was unique to that orange Lenovo that was stolen. And Clint Merritt with Lenovo helped Zeke Morse to realize that the computer that was listed on Craigslist on the 20th was exactly the computer, without a doubt, that had been taken from the Allister leasing office. Officers, you will hear, posed as a potential buyer, had contacted a person that they only knew as Mike from Craigslist to try and purchase that computer to find out if it might bring them to Melissa's killer. You're going to hear that they had set up an arrangement to come near the area of Walmart in Wake Forest, and that the buyer, who they later identified as Michael McCullum, kind of got spooked and didn't show up. They had already been doing some background on the Mike that had listed this computer for sale on Craigslist, and started doing some surveillance of his residence, of a car that they had determined he owned, and saw that when Mike McCullum, or the buyer Mike, didn't come to that meeting, that the car at some point left. So they did some covert surveillance, came to the Wake Forest Walmart, and at some point after a long, lengthy investigation, identified the defendant, Travion Smith, and Ronald Anthony as potential occupants of that car, or people meeting up with other occupants in that car. Both men were brought down to the Raleigh Investigative Division and were ultimately arrested between May 20th and May 21st for the death of Melissa Huggins-Jones. You're going to hear that that other laptop, the silver Lenovo that I mentioned, was also found in Michael McCullum's residence. And so they're trying to find out where the orange laptop is, and they're trying to find out where it has, and ultimately they during the investigation realized that it had been sold to a man identified as Julius Bumpers. And I believe he will tell you that Ronald Anthony, another co-defendant in this case, was the one who sold it to him, along with a girl who Raleigh Police Department later identified as Sarah Redden, who was one of Ronald Anthony's girlfriends. That brings Sarah Redden into the mix. She's invited down to the police department shortly after Ronald and this defendant, Travion Smith, were brought down, and she ultimately was arrested and charged in connection with Melissa's murder. At this point, now having leads and having suspects, the Raleigh Police Department is continuing their investigation. You're going to hear that they, during the course of the investigation, they learned that this defendant, Travion Smith, had left his residence in about April of 2013, about a month before the murder happened, and that he had been hanging out with Ronald Anthony, and that they had been living from place to place, But one of their primary residences, or one of the residences where they would go often, was to a woman by the name of Amber Alberts, who was another girlfriend of Ronald Anthony, the co-defendant charged in connection with this case. Amber's going to come in here and tell you that she saw them shortly after the killing happened, that both this defendant and Ronald Anthony had laptops that they had not had with them when they left on the Monday morning before Melissa's death. She's going to talk to you about the items that they had with them. She's going to tell you that after the arrest of both this defendant and Ronald Anthony, when she was going through her home, she also found an iPod that, when she turned it on, said Claire's iPod. You're going to hear from Claire Reynolds, who was one of the car owners that had been broken into that same night that Melissa was tragically killed. And that Amber Alberts will tell you that the person who used Claire's iPod at her home in Oxford, North Carolina, was the defendant, Travion Smith. Raleigh police are following leads and trying to figure out if there are any other folks that they can speak to in connection with this case. They speak with Amber Alberts' roommates, Joseph and Michelle Perry, who also tell you about how the defendant and Ronald Anthony would stay at their home from time to time and what they observed in their between the two of them after the murders happened. Meanwhile, you're going to hear, while Raleigh Police Department is conducting their investigations, you're going to hear that the City County Bureau of Identification, sort of our crime scene analysts, are going through the scenes that they processed, trying to look for evidence of latent fingerprints, trying to look for evidence that they can collect for what they believe to be blood specimens or blood spatters. You're going to hear about the scene and you're going to see how they found the scene that day, but they're going through and not leaving any stone unturned. You're going to hear that the latent fingerprint analyst who did the analysis tested approximately 158 or 160 fingerprints, or what she believed to be fingerprints, to see if they could bring anyone to corroborate what the Raleigh Police Department had found. And you're going to hear, and I believe you're going to see, and it's up for you to determine, images that the analysts lifted that they believed to be fingerprints, but may be what in fact were gloves. You're going to hear that the police department learned that both this defendant, Travion Smith, and Ronald Anthony were wearing gloves that day. And that may explain why they could not find any fingerprints to connect the two of them, because they were gloved. Meanwhile, while the City County Bureau of Identification is trying to go through their scenes, you're going to hear that some of the analysts at the State Bureau of Investigation Crime Lab are looking for DNA, and again, trying not to leave a single stone unturned. And you're going to hear about the blood evidence that they found and how they found Melissa Huggins-Jones' blood, not just in the bedroom where she was killed, but in multiple areas in the home. And at the end of the evidence, we'll explain to you why that's significant, but it was not confined just to her bedroom where she was killed. You're also going to hear from another CCBI agent who is certified to be a footwear expert. She's going to tell you that while her latent examiner was looking at the fingerprints or potential fingerprints in this case, she was asked to look at footwear impressions that were taken from the scene, from the brand new carpet in the downstairs leasing office, on the railing outside the balcony of the downstairs railing leasing office, even on a dryer vent up on the second store right outside the patio of Miss Melissa Huggins-Jones' apartment. She's going to tell you that she viewed those latent foot impressions, or what appeared to be footwear impressions. She's going to tell you that Detective Brady asked her to compare some shoes that were taken directly off this defendant's feet when he was arrested, as well as another pair of shoes that was identified as the one that Ronald Anthony would have been wearing. And she's going to tell you, in looking at those, and she's going to show you how she did her analysis with those shoe footwear, that she found several impressions that had some similar characteristics to the shoes that this defendant was wearing and to the shoes that Ronald Anthony was purported to have been wearing. And one of the things I anticipate she's going to tell you is that she found the footwear impression on the dryer vent, which is exactly how the state will argue to you that these two gentlemen got into her house. you're going to hear from her mother that you're going to hear from Melissa's mother that she had been at Melissa's home on the night that she was killed, or in the evening hours before she was killed. She's going to talk to you about the fact that the AC wasn't working, and you'll hear likely from the maintenance man who had come in trying to help her fix that air condition. And you're going to hear that when Miss Wallace, Melissa's mother, left that night, the balcony door was cracked because she was hot and the air conditioner wasn't working. You're going to see the footwear impression on the dryer vent just outside Melissa's upstairs patio, which I will submit to you. You can see what Agent Davis did in overlaying this defendant's shoe, again, that was taken off of his foot on the day he was arrested. And you're going to see the similarities or the similar characteristics that she found. And I'm going to ask you to pay close attention to that, and one of us will tell you at the end to think about what that means in terms of this defendant's culpability in this case. After you've heard all of the evidence, and I've outlined just a little bit about what you may hear during the case, but I would rather that you hear it from the folks that found Melissa, the folks that worked hard to try to process the evidence in this case, as well as the investigators that worked round the clock to try and solve this case and luckily got that break with the computers. But I want you to hear it from them. What you are going to hear during the course of Travion Smith was constantly with Ronald Anthony. When he was no longer living with his family, he went from place to place with Ronald Anthony. You're going to hear that he would attend Ronald Anthony's Marijuana's Anonymous meetings. And on the weekend before Melissa's death, you're going to hear that the two of them were staying at the Oxford home near with Amber Alberts. That morning, that Monday morning, that Ronald Anthony's mother picked them up to bring them down to Raleigh so that Ronald could attend court meetings and meet with court officials, and that they were hanging out that entire day. You're going to hear from folks that had never seen these two, that saw them together at the Ben & Jerry's, at North Hills Mall during the evening hours, at the Bonefish Grill during the evening hours, at the Marijuana Anonymous class during those evening hours, and you're going to hear folks that describe the two of them in the area of the car break-ins. They were together before the murder. You're going to hear that they were together after the murder, and the state is going to prove to you that they were together during the murder of Melissa on that warm May evening. You're going to hear after Melissa was killed that they didn't go their separate ways, that they still went together with Sarah to a hotel room. They went to Flashbacks, a club first, and then to the hotel. And then even as those computers were being sold, they were hanging out in the Andes in Wake Forest taking pictures together of that phone. Why is it important that they're together? Listen throughout the course of the evidence, because together, legally speaking, the state will argue to you that they were acting in concert, that they started the events of May 13th into May 14th together, that they completed the events of May 13th and 14th together, and that afterwards they remained together. You're going to hear that they were even together when they were arrested. During the course of the investigation, again, Raleigh's doing a lot of work, the City County Bureau of Identification is doing a lot of work, the State Bureau of Investigation is doing a lot of work, but I anticipate that during the course, after the majority of the work was done, that Travion Smith talked to some people about what he did. You're going to hear from what we argued or talked to you about in jury selection, 2 jailhouse informants. They're folks with checkered pasts and criminal records who spoke with the defendant. And I anticipate when you hear from them, consider how consistent what they tell you happened, their stories are. I believe that they're both going to tell you that Travion Smith is the person who first hit Melissa Huggins-Jones. And no matter how, on that evening, and no matter how checkered their past, between their criminal records and their potential mental health, how they could not have come up with the same set of facts, absent one man telling them exactly what happened. You're going to hear from them, and I imagine they're going to be cross-examined at length. But one thing that you will be able to tell after their testimony is they didn't know each other. Before this, they didn't know Travion Smith, and they couldn't possibly have known about what happened to Melissa Huggins-Jones in that apartment. Again, at the end of this case, one of the two of us, or perhaps both, is going to stand up in front of you and ask you to find the defendant, Travion Smith, guilty of first-degree murder. He's the only co-defendant on trial now. He's the only person for you to consider now. But he is guilty, both because he clearly was a participant in the burglary that led to Melissa Huggins-Jones' death, but also because when you see the crime scene, when you hear about the injuries to Melissa Huggins-Jones, this was not a one-time punch and she died. You're going to see the injuries to multiple areas of her body. And you're going to be asked to consider whether those injuries are consistent with a death that was premeditated and deliberate, because it didn't need to happen. And there was some period of time and thought when you look at the injuries to her body. I caution you to listen to the evidence that you're going to hear during the time that we're together, and all of you said that you could, and that you felt comfortable with assessing the credibility of the witnesses that will testify here today. And I'm confident at the end of all of the evidence that you're going to realize, and the state will prove to you beyond a reasonable doubt, that Travion Smith was not just not merely present during these events, but he was an active participant who showed reckless disregard for the life of Melissa Huggins-Jones. I want you to think about that and consider perhaps his statement to law enforcement in light of all the other believable evidence, which Judge Ridgway will instruct you at the end of this trial. And at the end of this trial, you will have no other choice, the state would argue to you, than to find the defendant guilty of the first-degree murder of Melissa Huggins-Jones. Thank you.
Thank you, Ms. Mr. Brown, for the defense.
Good morning. This trial is about Travion Smith, but this crime is about Ronald Anthony. Ronald Anthony, who is already serving a life sentence for the murder of Melissa Huggins-Jones, is the one who is responsible for her death. During the course of this trial, there's going to be a lot that both sides are going to dispute. But there's one thing that nobody is going to dispute. The death of Melissa Huggins-Jones was horrible, tragic, and completely senseless. She was a wonderful person, a loving daughter, a devoted mother. And it is absolutely heartbreaking that her daughter, Hannah, was the one who discovered her mother's body. No child should ever have to go through anything like that. No person of any age should ever have to go through anything like that. But we are here today to decide who is responsible for Melissa Huggins-Jones' death. In May of 2013, Ronald Anthony was 23 years old. And you're going to hear during the course of this trial that Ronald Anthony could be charming, likable, and charismatic. Women loved him. Men easily befriended him. But you will hear that Ronald Anthony had a dark side. He could manipulate people. He was a criminal. And on May 14, 2013, he showed just how violent he could be. During this trial, you're going to hear about two other people who were also charged with Melissa Huggins-Jones' murder, Sarah Redden and Travion Smith. Sarah was 18 years old at the time. She and Ronald had an intimate relationship. Although Ronald was living with his other girlfriend, Amber Alberts, Sarah thought of herself as Ronald's one and only girlfriend, She was infatuated with him. She loved him. And Ronald Anthony was able to manipulate his teenage girlfriend, Sarah Redden. And you will hear about Travion Smith. In May of 2013, Treyvion was 20 years old, 3 years younger than Ronald Anthony. Those who know him will say that he was even immature for his age. He was a follower, someone who could be easily manipulated by others. In 2013, Treyvion was kicked out of his home. He had nowhere to live. He was basically homeless. Given his age, his personality, and his situation, he became the perfect target for Ronald Anthony. Ronald Anthony befriended him. Ronald Anthony gave him a place to live. And Ronald Anthony started to manipulate him. On May 13th, Treyvion and Sarah met Ronald Anthony at his Marijuana Anonymous meeting. Ronald Anthony arranged for the three of them to get a ride to the North Hills area. And the three of them began breaking into cars. And let's be clear about this. It's wrong for them to break into cars. And Ronald Anthony, Sarah Redden, and Travion Smith all knew it was wrong. But when you hear evidence about what happened during that night, keep in mind this. There was never discussions among any of them about hurting anyone. There was never discussions about assaulting anyone. And there was certainly never any talk about killing anyone. At some point, the criminal activity that Ronald Anthony had led in the North Hills, streets of the North Hills, led to the apartment of Melissa Huggins-Jones. And there will be conflicting evidence about exactly what happened in that apartment, and even conflicting evidence about who was even present. But you will hear that it was Ronald Anthony who killed Melissa Huggins-Jones. Treyvion and Sarah never planned anyone's death. Sarah and Treyvion never intended for anyone to be killed. After Melissa Huggins-Jones' death, Ronald Anthony continued his role as the leader, and Treyvion and Sarah continued their roles as the followers. Ronald Anthony directed the escape from that area. He called his friend Maurice Brown, who picked them up. Maurice Brown and Ronald Anthony and the other two drove to a strip club called Flashbacks. Ronald Anthony and Maurice Brown went into the club. Treyvion and Sarah stayed outside. They weren't 21 yet and didn't even have the proper IDs to get in. Then Ronald Anthony directed that the three of them go to a motel and made arrangements for them to go to the motel. After Melissa Huggins-Jones' death, Ronald Anthony continued. After they left later that week, he continued his role as the leader. He decided what would be done with the stolen items that they had taken. A couple of laptops had been taken that evening, and he helped arrange what would be done with them. Ronald Anthony sold one of them, and he had Treyvion sell the other one. You will hear that it was the selling of these laptops that led to the arrest of Treyvion, Sarah, and Ronald Anthony. During the course of this trial, you will hear testimony of many people. You will hear that some of them have an extra incentive about their testimony. Some of them are criminals. And when you hear their testimony, pay close attention to what types of charges they were facing when the police talked to them, and how much time they were facing in prison. You will hear about the deals the state made with some of them, and you will hear how their testimony may affect how much time they will spend in prison and if and when they will ever get out. There will be other things about their testimony that you should also pay attention to. Some of them will have criminal records. Some of the witnesses in this vein will have serious mental health problems. All of that is fair things for you to consider. Treyvion did a lot of things wrong that night and in the days following the death of Melissa Huggins-Jones. He should not have been breaking in to cars in the North Hills area or being involved in any criminal activity. But Treyvion is not charged with breaking into cars. And he should have immediately reported what he knew about the death of Melissa Huggins-Jones. And he should have been not involved at all in selling any of the stolen property. But Treyvion is not charged with what happened after the death of Ms. Huggins-Jones. He is charged with only one offense, and that offense is first-degree murder. And the person responsible for Ms. Huggins-Jones' death is Ronald Anthony. Thank you.
Evidence for the state.
Thank you, Your Honor. Your Honor, at this time the state would call Mr. Robert Pittman to the stand.